All rise. We will lever. Please be seated. We will swap.
Thank you very much. Mr. Khan, you were on your feet.
I'm most grateful, Mr. President, and Your Honours.
Two more minutes, and then if you can wrap it up.
I'm most grateful.
I realize that Ms. Postman didn't get through 3 points. She had announced 3 points. I think she only spoke to one of them. And we will be coming back to quickly make the other 2.
Your Honour, I'm in your hands. I can deal with the points briefly now, or wait till my learned friend finishes.
Why don't you finish, since you're already on your feet?
I'm grateful. Your Honour, as far as the defence of Mr. Ruto is concerned, we can accept that in certain circumstances the word require can have a similar connotation to order. There wouldn't be much difference between them. But there's 2 observations I'd make with respect. The first, Article 64 is the general rule. And Article 93, particularly we say, Article 93 1E, is the lex specialis provision. And we shouldn't lose sight of that in overly putting the spotlight on Article 64 when we have a specific provision that deals with the situation at hand. But, Your Honour, even if, and I can concede that European countries by any stretch of the imagination. But the fact that it's there, that this requirement is explicitly pleaded, and it's an express provision, shows that the argument of the prosecution is without basis, because unlike those countries that have agreed to compelled evidence by video link, the Rome Statute does not include it. On the last point... Mr.
Khan, we have to leave it there. You were living on borrowed 2 minutes. We may come back to you later. We may come back to you.
I'm grateful.
Ms. Busman.
Thank you, Mr. President. Just one issue on the requirement definition. I just wanted to point out that we looked at the Black's Law Dictionary and some others as well, all legal dictionaries. None of them have actually given a precise or any definition at all of require, which shows to us that this is not a very clearly defined term and it is subject to interpretation. We do say that require was used deliberately rather than order, and although we agree also with the submissions made by Mr. Khan that there is some it can be some obligation on the require, but not the one that we're discussing here. As I said earlier, it is more to the parties to maybe help and facilitate to bring an additional witness to the court.
Mr. Busman, the
Yes.
difficulty I had, which I was expressing, is that there's a difference between saying the court does not, which was what you started with, that the statute does not allow a witness to be compelled. As a separate matter from whether the statute contemplates that a state party, in virtue of assistance, may be required to compel the witness to attend. These are two separate things. And that is where we have the distinction between what Article 64, 6b and Article 93 say. That's the point I was trying to make with you. But if you can speak to your next 2 points, quickly, please.
And just, I understood the point, and we still maintain our position that Article 64 does not give this power because it's not linked to any sentencing requirement. So nowhere in the statute is there any provision that allows you, the court, to subject someone who's unwilling to testify to sanctions. So that's our argument. On the other points, in terms of the states, the prosecution has made a distinction between those states that have actually explicitly authorized some compellability of witnesses before the ICC. Then they say there are states that have not explicitly denied that power, and then there are states that have actually only authorize voluntary participation. These are the 3 groups that the prosecution has identified. We submit, we leave out the discussion on the first group, which we have already discussed, but even if you were to disagree with me that the group where they explicitly authorize this, that they can actually compel witnesses to testify, we do not think you can make a distinction between those that have not prohibited it. You cannot force a state that hasn't explicitly prohibited the power of compellability, the power of subpoena of witnesses. Such a state cannot be compelled under a very vague provision which says other assistance, any other assistance not prohibited by law. We submit this is just not an explicit enough provision to compel a state that has not actually authorized in its own law, authorized the court to compel witnesses.
All right, can we focus the discussion so that it's real? We now are dealing with Kenya, so we don't need to account for what every other state has done in this regard. If we can deal with the situation concerning Kenya, and which is what we're dealing with now.
It's in our submission, Kenya is actually a country where it's actually not authorized. So it's not even in the category where the prosecution places Kenya, that it's not actually explicitly prohibited. We say it is. But obviously I don't want to speak for the Kenyan authorities who are here with us today. I can point it out in our submission. This is paragraph 66 up to 75, where we deal with the Kenyan law, and as we have highlighted, all the provisions require consent of the witness who is subject to any summons. So if you read in our submission section 86, in light of the following sections, 87, 88, 89, then it's clear that the summons that can, 86 speaks about a summons requiring a person to appear as a witness. This must be read in our submission, but again, the Kenyan authorities will deal with this in more detail. It has to be read in light of 87, 88, 89. And this is all about voluntary participation. In fact, it goes so far that it imposes an obligation on the Attorney General to inquire with the witness whether or not the prospective witness will consent to giving evidence or assisting the International Criminal Court. And that last part we think is important because it doesn't distinguish from testimony here in the court or giving assistance in any other way, which of course is not dependent on the region. So
Sorry, can again, I just turned to 86. Are you talking about section 86(3) of the ICA?
Indeed.
And you're saying, and this provision says, in this section, document, let me back up. No, back up. So the provision begins in subsection 1, where the ICC requests assistance under paragraph 8, Article 19. I see Article 64, or paragraph 1D of Article 93 of the Rome Statute, in arranging for the service of a document in Kenya. And then 86(3) says, in this section, document, quote unquote, includes a summons requiring a person to appear as a witness, and B, a summons to an accused. So here we're dealing with sub 3A. It says a document includes a summons requiring a person to appear as a witness. So you're telling us that the ICA does not contemplate serving an order to a witness to appear. Is that what you're saying?
What I say is that this section must be read in light of 87 and 88 and 89. And if you look at 89(1)(a), it explicitly states the Attorney General shall assist in the making of arrangements to facilitate a witness's attendance before the ICC if he is satisfied that the prospective witness has consented to giving the evidence or assistance requested. And I think the main disagreement here between us and the prosecution is that they make a distinction between testifying here at the seat of the court and testifying in Kenya. And we say that is an erroneous interpretation of the law of Kenya as well as the Rome Statute. Because when someone testifies in Kenya, it would still be a testimony before the seat of, before the ICC, even if not. The physical presence might not be here. It's still a testimony before the court. So in that sense, I do want to leave it to the Kenyan authorities to give the proper interpretation to 86(3)(a, and if there is an inconsistency with 87, 88, 89. But on the face of it, in my view, in our view, there is no inconsistency, because it's one thing to submit a summons and requiring a person to appear, but it is another thing to force a person, if he's unwilling to appear, to force him then, either through a fine or through imprisonment. That is a whole next step, and that next step is nowhere to be found in this law. It's only found in another law that the prosecution is trying to transplant into the International Crimes Act.
What law?
It's the criminal procedure. And
the Criminal Procedure Code?
Yes.
Oh, right. Okay. But is it necessary to have sanctions before an order is an order?
Well, we submit that if there are no sanctions, then you cannot enforce that order in the case that someone is unwilling. If someone is willing, there's no problem. There's no problem requesting a witness to testify, to submit a summons, and if the witness is willing, then there's no issue. But if the witness is unwilling, then you need an authority, a force, a power to compel this witness.
Yeah, but isn't that a second stage? The question is the character of the whole process itself dependent on that second stage, so that an order of the court or a summons or subpoena, as the case may be, it isn't what it is, what it should be, if it doesn't, if there is no ability to enforce it through sanctions.
Mr. President, we have no problem with this court asking Kenya to issue under this section a summons requiring these persons to appear. But if these persons then do not so appear, we do have a problem with the second step and say, well, you have to oblige them to appear. We say that there is no provision for that, there's no authority for that. That is our position.
Maybe the prosecution during their turn will speak to that and whether or not that is what they are contemplating as well. And the reason I say that, I think Blaskich might have said something different. Somehow it may not be directly on the same issue. But I remember the appeals chamber did not always require sanctions to be in place before a subpoena is seen as such. Particular regard to states, subpoenas to states or officials of states. Think that point. Anyway, you speak to it when we come. Please proceed.
The issue here is compellability, Mr. President, and we say there's no such thing as compellability. Whether we call it subpoena or summons, there's obviously no problem submitting a document asking these witnesses to appear. And I think this is where we may disagree. I already stated earlier that there's a difference between ICTY and ICTR on the one hand and the ICC on the other. And in Blaskich, they've also recognized a direct relationship between the court and individuals. So you can bypass state cooperation by going directly to the individual. In our submission, you cannot do that in the ICC because ICC depends on states. It's an agreement. It's the states that have actually ratified and signed the Rome Statute. You cannot bypass them and create a direct relationship with the individual. I think that for us is also a distinction. And I think I leave it for here and wait for other replies later on.
Thank you very much. Mr. Attorney, I think it's your turn. I know you're a professor of law, but we still have time limits.
Thank you very much, Mr. President. I want to reiterate the gratitude of the government of the Republic of Kenya for this opportunity to participate in these proceedings. We have had long and protracted discussions about how we can assist the court to arrive at a fair and just determination of the matters before it. I want to start also by saying, Mr. President, that I would wish to commend the prosecution because in 5 years of engagement with the government of the Republic of Kenya, this is the first time that the prosecution has said that the government of Kenya is capable of being entrusted with a weighty matter of A, getting to know the witnesses, and B, assisting in the taking of the testimony of the witness. This is a 360 degrees about turn. What the prosecutor has consistently said since this case commenced is that the government of the Republic of Kenya cannot be trusted at all with the witnesses. So we welcome this change of heart. And having said that, however, let me also confirm this. The government of the Republic of Kenya is committed to its treaty obligations. And the government of the Republic of Kenya will enforce the Rome Statute. And the government of the Republic of Kenya will enforce its own International Crimes Act that has domesticated the Rome Statute. That is our commitment. Now, what is our understanding of the law? Happily for us, we do not share the views expressed either by the defense or by the prosecution that there is a complex question of law that requires much learning to resolve. The Kenya government takes the view that what is before the court is a very simple, very straightforward issue, and that we can resolve it if we have fidelity to the treaty and to the Kenyan law affecting the treaty. We have raised, Mr. President, 3 issues only, and I'll try to be very brief in my submission. In my submission filed with this court on the 10th of February, I have raised 3 very straightforward issues, and they are as follows. Number 1, that in our reading of the treaty requires the voluntary appearance of witnesses to testify before the court. Whether the court be sitting here at The Hague, which is its seat, or in any other venue. That is our reading of the treaty, and we will explain why briefly. Secondly, it is our view that neither this court, as a judicial organ, nor the prosecutor, as an organ of the court, can impose on any state party any obligations that don't directly flow from the treaty itself. And we will explain why. We will be saying neither the government of the Republic of Kenya nor any other state party should be obligated to assume any responsibility that were not expressly assented to at the date of the ratification of the treaty. Finally, our third and final point, we will be submitting to you, Mr. President, and the court, that the prosecutor's reading of Kenya's law regarding the appearance of witnesses is wrong. And we will be submitting that under the law of the Republic of Kenya, which has domesticated the Rome Statute, the government of the Republic of Kenya cannot, without violating the Constitution, compel any person who does not volunteer to be a witness to become a witness. Let me now go to my first point, very...
Mr. Mugai,
yes,
before you proceed, so that we clearly understand what the problem is. I'm thinking here about 3 scenarios. One is a scenario in which, let's assume, the prosecution is able to persuade the court that the court has a power to compel a witness, quite apart from what the government of Kenya does about it. And the court issues an order that a witness should appear, and then on the basis of that order makes a request. And what we're now working with, this is scenario 1, is only the order of the court coupled with a request. Some may say there's an expectation or not that the government of Kenya may act upon it. That's one scenario. Second scenario is there is the order and the request, but armed with that order and the request, the government says, all right, we will go to a domestic court and on the basis of this order and the request, domesticate the request, so to speak, or the order, and then gets a high court order with its own subpoena. That's the second scenario. And the third scenario is it doesn't matter whether or not the request of the court is propelled of its own force or is assisted by a domesticated court order from Kenya. It doesn't matter. The point is, request would not be, it's not appropriate, it will not be allowed. Which is the position?
Sorry, Mr. President. As I understand the prosecution's application, and I stand corrected on this, they wish that the government of Kenya be directed by this court to facilitate these 7 witnesses to appear at some forum, which I believe is a forum within the territorial jurisdiction of Kenya, and by some process, which is to be discussed at a later time, their evidence be taken in a process that is adjunct to this court. I do not understand that the prosecution is interested in a purely Kenyan domestic process. In fact, I understood my learned colleague, the prosecutor, to have said this morning that that is an avenue they do not wish to explore.
No. I may have misstated the scenario. What I meant wasn't a matter of what I described earlier as rogatory commission, but a scenario, in the second scenario, I mean, where the request is made and then operating under the principle of international law, the general one, that states, it's up to states how they implement their international obligations. I believe the ICJ recently said that in the His and Habra case, confirmed that. But I'm saying, request is made. The Attorney General, that is you, decides, all right, the most appropriate way to move on this request is to take this request to a Kenyan judge who will then issue summons to a witness to appear before the ICC, not to appear before a rogatory commissioner, the person of a high court judge, to take the evidence. But Kenyan court directs a witness, ICC wants your attendance, the Attorney General has made this application for me to issue summons, I'm issuing a summons to you, witness, whoever, appear before the ICC and give your testimony. Do you rule that out as well?
I would take the view that I would have to address you on the first question first, because the position of the Kenya government is that this court should not even contemplate the possibility of issuing such an order, because this court will have acted in violation of the statute. However, if I do not persuade you at the end of that argument, then we will come to the secondary argument. Supposing you issued the order in any event, what would we do with it in Kenya? And I would come to the point you are raising now, if I may. So I will be very brief on this question of international law, because it's been argued in my very humble judgment in a very persuasive manner by those who have spoken before, especially Mr. Ruto's defense and Mr. Sang's defense. And I want for the record to say the Kenya government is in complete agreement with their understanding of international law. In particular, Mr. President, the learned opinion of this Dutch academic, Mr. Sluiter, in this very seminal and interesting article, I beg you please come to testify the problematic absence of subpoena powers of the ICC. We have perused this article and must commend this gentleman because in our judgment, he captures the problem of the matter before you very, very well indeed. And we agree with respect that his conclusions are the correct conclusions.
So, Mikai, see, while you're on that point, when the debate was occurring before you stood up, I had brought in the comparative situation of the ad hoc tribunals. And I made the point that if you took the statute of the ad hoc tribunals, ICTR or ICTY, and stood it side by side, ignoring the rules, you might actually see the absence of the phrase require the attendance of a witness as you have it in 64 6B in this statute, in the statute of this court. It is there. You don't even have anything as close to that in the statute of the ad hoc tribunals. But they still recognize the power of issuing subpoenas and summons in the rules of the court and in the subsequent judgments of the court, both of which, I mean, the rules and the judgments are judge-made norms. Why do we say that this court is in a worse position than the ad hoc tribunals?
The answer was provided by the Sang defense a few minutes ago. The Rome Statute was negotiated by states. And Mr. President, I have had the distinct privilege to attend and participate in the deliberations that take place in the Assembly of State Parties. It is a political forum, and there is a lot of horse trading, and a lot of parties that feel that extreme positions jeopardize the package that you want to carry. And in my own readings about the preparation of the Rome Treaty, there were a lot of states that were very concerned about extreme positions that would jeopardize a package deal. And Mr. President, you are familiar with this.
BY 93, is that 1L?
Yes.
Says what it says.
Yes, yes.
Because of the horse trading, perhaps lack of agreement on explicit positions, then we have that open-ended mechanism there. Could it be why that is there? I don't know, I'm asking
That's
you.
right. That's why, obviously, you can see there, Mr. President, that is exactly why a draftsman would introduce 93(1)L. Because there is, obviously, there was a difficulty here carrying a consensus that state parties would be obliged to arrest their countrymen, arrest their subjects, their national, compel them to appear, and at the pain or at the risk of a term of imprisonment or other consequence, bring them to the court. Many states were very uncomfortable with that sort of.
So then that then boils down, does it not, to what each state's party chooses to do.
Exactly.
In its own law.
Exactly.
Which takes us now to the ICA and what it actually says.
Yes.
Yes.
Indeed. And I want, even before I go there, I want to draw your attention, Mr. President, to something that hasn't quite been alluded to this far. In the rules of this court, in Rule 65, is a very, in our view, illuminating provision, providing as follows. Mr. President, compellability of witnesses. Compellability of witnesses. And it says 65(1). A witness who appears before the court is compellable by the court to provide testimony unless otherwise provided for in the statute and the rules. A witness who appears before court. Our own reading of that is that this is a witness who has come to the court voluntarily. This is a witness who has submitted to the jurisdiction of the court. And under the jurisdiction of the court then is entitled to say, you are here, we have your statements, all statements, you are under an obligation to do this.
Is Rule 65 a general indication of general rule of compellability of a witness at large? Or
No.
does it speak to precaution? Is rule
You see, if Mr. President, you will look at the heading of Chapter 4, it relates to provisions relating to various stages of the proceedings. So this witness in Rule 65 is already before court. His attendance has been obtained by a process that the court itself sanctions, is legitimate and is legal. It is only then, when all these processes have been complied with, that he becomes compellable. That is our submission. Now, let me come to the obligations of a state party, and in this case, the obligations of a country like the Republic of Kenya. We submit that Article 64(6)(b) and Article 93(1)(d) do not empower the court to compel witnesses' attendance and testimony. And we want to agree totally with the very, very lucid submissions of Mr. Karim Khan QC, that where the rule is specific, it overrides the rule that is general for purposes of the specific application. The rule that should concern this court is not the general powers of the court, it is the specific powers of the court. This is our submission. If you look at Article 64, Mr. President, Article 64 has a subheading that says the functions and powers of the trial chamber. And it says in 64(6)(b), they will require the attendance of the testimony of witnesses, etc., etc., if necessary, and the assistance of states as provided in this statute. 96(6)(b) is not conclusive. We have to go to what then does the statute provide. And in our very humble view, that is again very clearly taken care of by 93(1)(d), I think it is. Because 91(d) says the service of documents including judicial documents, and then L, any other type of assistance. In our submission, nothing could have been clearer. If the draftsmen of the Rome Statute intended compellability of witnesses generally, nothing would have been easier than to donate that power expressly. It was not donated.
64.6b,
64.6D, sir?
64.6b, the
B.
one you just referred to. What does it tell us if it says require the attendance and testimony of witnesses and production of documents and other evidence by obtaining, if necessary, the assistance of states as provided for in this statute?
I can
Say,
think,
if necessary.
if necessary.
Does it tell us that there may be circumstances where it may not be necessary to obtain the assistance of states? Now, if we can envisage that possibility, what does that do to the argument that witnesses are non-compellable? That's a general proposition.
I would start by saying, Mr. President, as you may know, as you do know, sir, the witnesses before this court are not known by the Kenya government at all. We cannot put a name to any person. We have never been part of the process of discovery. To the extent that the Kenya government is aware of any witness, it's the witnesses that have already testified, and most of them have done so in camera in this chamber. How did they arrive at The Hague? We don't know. We don't know. We assume, therefore, that they are covered by 64.6b, that they came here without the requirement of any assistance by the state party.
There you go. Now, let's stop there for a minute. You've engaged that scenario, and in my view, it is a very important one. Now, let's say a witness, mind you, we're still dealing with the theory that witnesses are not compellable.
True.
Okay. We have a situation you've just invoked. A witness arrives at The Hague with no help from you or state party.
Yes.
But while the witness is in The Hague, time for testimony arrives. Witness said, no, I don't want to come. They're still in The Hague, in the custody of, or in the care of the VWU. Are you saying that they cannot be compelled to appear? When the witness comes and tells the judges, look, I know what Article 64.6b says. It says I cannot be compelled. I'm here against my will. I will not testify. Are you saying that is what 64.6b contemplates?
I think by your Rule 65, if the witness is sitting before you in this court.
No. They've not yet come. They're in the...
Is he in Kenya?
Where, no, he's in The Hague.
He's in The Hague.
In The Hague, but refuses to come. So that is where the compellability issue begins. Time to testify, witness, VWU go to get the witness. Witness said, I've changed my mind. I don't want to attend court anymore. So you have the compellability issue engaged from that point. They're not in the court yet. Mm-hmm. Are you saying that they could not be compelled to come? Or worse still, let me make it even perhaps cleaner. VWU go. Witness said, I don't want to come to court. And the VWU come to court and tell the judges, sorry, the witness does not want to appear. What do we do?
I would imagine that that is an issue that does not. The fact that he's a Kenyan witness is immaterial. I assume that this applies to, you are asking a witness across the board.
We are dealing with the theory of non-compellability, which everybody is arguing. The court cannot compel a witness to come to court and testify. Witnesses are voluntary in the ability to come to court and testify. Yes. And now we have this scenario.
I think that the distinction you make is important, but there is one that I cannot speak to. I can speak to this. If the witness is within the territory of the Republic of Kenya, the answer is no. That witness is not compellable by you and is not compellable by us. If
Why the distinction? Why do you make that distinction? Because does that imply that you may give some ground in the scenario where the witness is already in the Netherlands, in The Hague, but does not want to come to court?
Yes.
It's saying a distinction can be made. Do I take it you might agree in that sort of scenario that, yes, 64(6)(b) might mean the court may compel the witness to attend?
Well,
because the witness is in The Hague.
I have considered
considered
one thing, sir. Let me make it clear what I have considered. I have considered that when you have a live witness in front of your trial chamber who has been sworn and is about to commence his testimony, if he purported to refuse to testify, I think you have clear legal mandate to compel him.
That's not an issue. The issue is the other one, where the witness is in his bedroom or his
If
flat,
the witness is at The
come.
Hague and is in some hotel and refuses to come to court, are you asking me whether you have the authority to issue an order for his arrest and production before the court?
According to your view of what 64(6)(b) means, yes.
Let me concede that because it is immaterial to our own case. And,
Right, so you concede that. Now let's move forward.
let us concede that that would be somebody else's headache.
All right.
It wouldn't be the headache of the Kenya government.
Good.
But I concede that if this witness is a witness already in the seat of the trial court, brought to the trial court through a regular, legal, legitimate procedure, there may be a residual authority on your part to compel him to testify.
Right.
But let me go to
hold on,
others.
before you go on, I won't push you further on that to concede more than you've done. Now, the question now is, we move forward. You said, all right, but if the witness is in Kenya,
Yes.
it's a different matter.
Absolutely.
Why?
Because the law that we shall enforce in the Republic of Kenya is a law that even 64(6)(b) recognizes.
What is that law?
It says, require the attendance of the witness.
Well, what are you looking at? What are you looking at?
Let's take the comma, Mr. President, that you alluded to earlier. Comma, if necessary, comma, the assistance of states as provided by the statute. The procedure of the assistance of states is not in 64. It is in 93. And 93 then says that the state will invoke its own domestic law. And when I receive your request, if that day ever comes, if I receive your request, my concern, the concern of the DPP, the concern of the court shall be, what does Kenyan law, which the statute has recognized, say? One of my fundamental duties as Attorney General is to satisfy myself that this person is voluntarily. And that's the language. It's the language of the Rome Statute. It's the language of the ICA. If I am satisfied, now I am assuming, Mr. President, sir, first, I don't know who these 7 people are. I'm assuming through some process, the prosecution will make them known to me. Then I am assuming through some process that they are still within the Republic of Kenya, which they may or may not be, I do not know, right? Assuming we can overcome all those hurdles, then we would have to overcome another hurdle, that I can find them.
And that's a problem you have in it.
Having found them,
Yes.
the last one, I am assuming I can obligate them through some method or other to come to me and let me know, do you or do you not wish to testify? Because my responsibility is triggered once I can make that determination.
Now, we've looked at earlier during the argument, that was Mr. Brisbane referred us to Section 86.
Section
86.3 of the ICA.
86.3.
Which contemplates that the assistance that may be rendered by the government of Kenya pursuant to Article 64 may include service of documents, and documents would include, quote, a summons requiring a person to appear as a witness, unquote. A summons requiring a witness to appear. Are you saying that Kenyan law, in light of 86.3a, does not contemplate the ICC summons to a Kenyan witness to appear? Even though it's...
I welcome the opportunity, Mr. President, to make that clarification because it's fundamental. In the argumentation between the prosecution and the defense, I got the impression that summons was treated as a hostile instrument. It need not be. In the criminal process, you can use a summon even to bring to court a friendly witness. Let me give you two examples. You can have a witness who says, I am able, ready, and willing to come to the court. However, the Kenya government has failed to give me a passport or to facilitate a travel document. You can issue a summons to him, which then is enforceable in Kenya. He is a volunteer witness. What the summon does is obligate the Kenya government to facilitate his appearance. What is the facilitation? To grant him a travel document and such other support as he may require. That's one scenario. Scenario number two, Mr. President, a witness says to the prosecutor, I am a medical doctor who works in a government hospital. I want to come and testify, but my superiors have refused to grant me leave from my job. Again, the court can issue a summons for him, although he's a friendly witness, because the summons becomes the basis upon which he activates the cooperation of his employer to come to court. It is an entirely different situation where the person sought as a witness is saying, A, I do not wish to testify. 2, I do not wish to leave Kenya. 3, I do not wish to be associated with this process. For reasons that I have never seen the affidavits, I assume they are in the, and I don't need to see them, but I think the import of the affidavits is that that's what the witnesses have said.
Yeah, but the conception of summons doesn't depart, does it, from an understanding of it that the idea of it is you receive that document as a witness, you must go to court whether or not you like it. Isn't that what summons means? You shall appear before the court.
I think that when the court issues a summons, it is expressing the hope that the person to whom the instrument is addressed will comply.
The incidence is they have to comply. It isn't a voluntary matter for them anymore once summons has come into the picture.
I would have my own difficulty with that. Whatever the court may intend, the court can issue summons, for example, Mr. President, let us assume that the court sitting at The Hague, the district court, I don't know the court structure, issues a summons for the President of the United States of America to appear in a Hague court while he is attending an international conference in The Hague. Does it mean the President of the United States is going to appear before that court?
It's a question of, no, it doesn't change the meaning of the word summons.
Yes.
It doesn't. The question is what happens then, whether or not the summons is violated or not, isn't it the question?
But the court has issued a summons in vain, Mr. President, because the President is immunized by international law, as is a minister, as is a diplomat, as is a person who enjoys immunities. So that I, as a minister of the Kenya government, if I were summoned by the district court here, I would send learned counsel to say, I will not be appearing before that court.
Yeah, but
that court has no jurisdiction over me. I enjoy immunities under the Vienna Convention.
That's an argument you have to make in defense in order to stave off the incidence of the summons, isn't it?
And that's why in international law, Mr. President, we do have an appearance and a protest, where we say the government of the Republic of Kenya were sued in a court here in The Hague. We would say, we do not admit the jurisdiction of the court. We have made an appearance and a protest, meaning the summons requiring the Kenya government to appear and defend a suit will not be recognized by us as such. But we will be saying, for the purposes of persuading that court that it has the wrong people at the wrong time. So let me take you to 87, Mr. President, sir. 87 is very, very clear because it is what captures everything that's gone before. It says where the ICC requests assistance under those paragraphs and those ones, and Article 93, the operative paragraph. Under Article 93 of the treaty, in facilitating the voluntary appearance of a witness. Nothing could be clearer than that in elucidating this point. Where the ICC has made a request for assistance in facilitating the voluntary appearance of a witness, the Attorney General may give authority. My first question when I receive this request, in whatever form it may come, I will ask myself and my legal advisors, is the person sought by the court appearing voluntarily? The prosecutor tells me, not at all. These persons, not only have they left my protection here in The Hague, they have also gone back to Kenya, that's what he says, and even in Kenya, I have gone after them and spoken sometimes to some of them on the phone, and they have said, never, never, never. So that is the difficulty I would be facing.
But the idea of voluntary appearance, what does it really mean when it is indicated in Article 93 and brought into Section 87 of the ICA? could it mean more than a witness says, I want to go and testify at The Hague, and the government is aware of this and says, oh, good for you, thank you. You're on your own, go. He says, but I can't go. So, well, that's up to you how you get there. Doesn't 93 say, no, it is not for you to tell the witness, good for you, it's up to you how you get there. It is for you to kick something in motion and make sure that a witness who wants to come does come.
Oh, there, I want to concede that point.
Hold on.
Let me
even could be worse than good for you, go. Could also be witness wants to come, but I'm not present, company accepted, of course. Certain government might then put certain obstacles in the way of the witness really coming. Isn't that what 93 is meant to avoid by the concept of voluntary appearance in
And I have considered that point.
All right.
I have considered
why do we
that
need to take
where
it
the
more?
witness himself wishes to testify, there is a positive duty on the part of the government of the Republic of Kenya to facilitate that person to go and testify wherever the forum will be. I want to concede that point again on the record, so that even tomorrow, whenever I get back to my office, if I receive from my learned and distinguished friend, the prosecutor, a letter saying, since our appearance in court on Friday, witness number 30, whatever the wording is, has indicated to me that he is willing to testify if you provide an avenue for that. My response instantaneously will be, no problem, no problem. But if he wrote to me and said, do you remember the 7 witnesses we were discussing? Have you now found them? And assuming by some miracle I had found all 7, and they had come to my chambers, and I had put the question, do you wish to testify in the ICC case number 2? And all of them had told me no. And had I asked them, will you make an affidavit confirming that this is something you have consciously decided? Then I would have to write back to my colleague and say, I regret that I am unable to process your request because there is no voluntariness. And allow me, Mr. President, to make this point. The International Crimes Act of Kenya makes reference to voluntariness 3 times. And with your permission, let me take you through that in 2 seconds. 87, I want you, Mr. President, to read the marginal note. What does the marginal note say? Request for voluntary appearance of witnesses. It is beyond dispute that the intention of the legislature is to legislate for the voluntary appearance of witnesses. But read the marginal note further. It says, this is to give effect to the Rome Statute, Article 19, 56, 64, 91. Let me take...
That's the marginal note. It is a marginal note. Now, one can say that you don't need to take us in the various places where the ICA mentions the idea of voluntary appearance. What perhaps might be of some assistance is where the ICA says the only way that a witness may appear before the ICC is by voluntary appearance. To see where it says that the only way that a witness may appear, or that the only way, or the only assistance that the government may render in relation to appearance of a witness is if the appearance is voluntary. Does the ICA say that? If it is, can you tell us?
It need not say that.
Okay, then can we look at Article 20, sorry, Section 20 of the ICA?
Article 20, sir?
No, Section 20.
Yeah, the request for assistance.
Section 20.
Yes.
Forgetting 21, let's look at 22. 20 sub 2.
20 sub 2. Yes.
What are we to make of this provision in that place? Nothing in this section A limits the type of assistance that the ICC may request under the Rome Statute or the ICC rules, whether in relation to provision of information or otherwise, or B, prevents the provision of assistance to the ICC otherwise than under this Act, including assistance of an informal nature. What are we to make of this provision?
Oh, this is what a draftsman would use to try and create a residual jurisdiction in the likely event that the entire 21, which is a very, very exhaustive, has left out something. And I want to draw your attention first to when they say the assistance that the ICC may request under the Rome Statute or the ICC rules, whether in relation to the provisions of information or otherwise. What does this mean? Where the ICC statute or the International Crimes Act has made a specific and detailed procedure, 20 subparagraph 2 is of no use. You cannot say to me, my learned friend, my learned and distinguished friend, the prosecutor, cannot come to me and say, Mr. Attorney General, I agree with you entirely. My case fails to fall under 87, 88, 89, 90. But isn't there a residual process where I can request you as two lawyers, as two gentlemen, can't you not assist me generally speaking? The answer is no. No. I can only assist you in the strict language of the statute.
Can you look at Article 23 of the ICA?
Yes, where in 23, Mr. President?
Article 23 of the ICA, subsection 1.
Yes.
If the ICC makes a request for assistance, the request shall be dealt with in accordance with the relevant procedure under the law of Kenya as provided in this Act.
Yes.
And B, if the request for assistance specifies that it should be executed in a particular manner that is not prohibited by Kenyan law, or by using a particular procedure that is not prohibited by Kenyan law, the Attorney General or the Minister, as the case may be, shall use his best endeavors to ensure that the request is executed in that manner or using that procedure,
Yes.
as the case may be,
Absolutely.
unquote.
Absolutely.
When we look at 20 and 23, am I wrong in getting this picture? That there is no limit to the type of request that the ICC may make, one. Second, the silence of the ICA does not prevent the government rendering any assistance that the ICC may make. 3, if the ICA provides for the procedure to be followed, that procedure shall be followed. But if ICA or any other law does not specify the procedure, then the Attorney General shall make his best efforts to act on the request as long as it is not prohibited by the law of Kenya. Isn't that the sum of it?
I regret I am unable to make the same reading. Section 20 of the ICA states in the marginal note, and permit me to use the marginal note, that is the tradition. The marginal note explains what the provision is intended to achieve. It says requests for assistance. Then it sets out in Roman numerals about a dozen different ways, in excess of a dozen different ways in which Kenya will provide assistance. Where 20 expressly provides a method, 22 cannot provide a residual method. So where I am told, Mr. President, where 87 tells me, if you receive a request under 93, you shall do the following. I cannot then say, I will not ask these people whether they want to appear voluntarily. I shall not make this inquiry. I will go and find something that may enable me to go in the penumbra area and act against a specific and direct provision of law. I will not do that.
You will need then to identify a specific and direct provision of the law that says you should not or you may not do that. Isn't that what is required? And that is what it seems to me
Yes, indeed.
Section 23 is saying, unless you can identify a law that specifically and directly says you may not do that, you have to use your best endeavors to act on any request that is made.
Luckily for us, in the sort of application that has been made or is sought to be made by the prosecution, there is direct law, direct, clear, unambiguous law.
What is that?
It is here, Mr. President, sir. It is 87. I shall be required to provide assistance for the voluntary appearance of a witness. That is what has to happen, period. And unless that happens, no residual, no creative construction of this statute can give me any authority, can give a court in Kenya any authority. And I venture to suggest, with the greatest possible respect, as counsel, not as Attorney General of Kenya, as counsel independently admitted to practice before you, I venture to suggest, with great respect, neither should this court.
So, Mugai, we already recognized your standing in very many ways.
I appreciate your very kind comments, Mr. President.
And in light of that, of course, I still in the same zone as the discussion we're having. On the 8th of April, 2013, you filed a process in the court, filing number 670, and at paragraph 36, you say this amongst other things. I think the second sentence, quote, after promulgation of the new constitution, think I'll take it from the beginning, the whole passage. Paragraph 36. Quote, on the 4th of August 2010, the Kenyans ratified a new constitution. The new constitution incorporates all international treaties ratified by Kenya as part of the country's laws, including the Rome Statute, to which Kenya is a signatory. After promulgation of the new constitution, the ICC became part of the judicial system of our country. Unquote, I'll leave it there for now. Now, ICC became part of the judicial system of our country. Surely that was an informed comment and not just an apostrophe that was made to make you and those who are listening to you feel good. Question is, what does that mean, that ICC has become part of the Kenyan judicial system?
I think it means what it would mean if I told you, Mr. President, that the East African Court of Justice is part of Kenya's judicial system. It is available to resolve disputes touching on the Republic of Kenya, and it is available also in appropriate cases for the resolution of disputes involving Kenya and our neighbors. The same way that Kenya is part of the International Court of Justice. The International Court of Justice is part of Kenya's judicial system. The minute you ratify a treaty with a judicial component, that court becomes part of your judicial structure.
But it means more than merely ratifying the treaty, does it not? Let's look at Section 4.
Yes.
Section 4 of the ICA.
That's right, sir. I'm there now.
All right. Title, Rome Statute to have force of law.
That's right.
And the provision, sub 1, the provisions of the Rome Statute specified in subsection 2, opposed to say that doesn't mean everything in the Rome Statute, but says specified in subsection 2, shall have the force of law in Kenya, shall have the force of law, that is direct force of law in Kenya, in relation to the following matters. A, the making of requests by the ICC to Kenya for assistance and the method of dealing with those requests. C, the bringing and the termination of proceedings before ICC. And in sub 2, it tells us that the relevant provisions of the Rome Statute are, remember, said relevant provisions that have the force of law. Sub 2E, Part 6, which relates to the conduct of trials. We'll stop it there. Part 6, that is where 64 6B falls. That's it. Now, this is the direct provision of the ICA that makes those parts of the Rome Statute the law in Kenya. And we also know, do we not, that the second schedule to the ICA is the Rome Statute itself. Does it not tell us that the ICC has then, to that extent, it bears out your comments that the ICC is part of the judicial system of Kenya to that extent? Isn't that the case?
No, it is not. Section 4 of the International Crimes Act is standard in any statute that seeks to domesticate law because what it is trying to do is draw a distinction between what appears in the treaty that Kenya has accepted and what Kenya has not accepted. If I was a draftsman and Kenya had accepted the entire Rome Statute, I would have an International Crimes Act that would be one sentence. The Parliament of the Republic of Kenya hereby enacts the International Crimes Court Statute to be part of the law of Kenya. Full stop.
And then
we would
append a schedule.
And then we would make it a schedule. The reason the draftsman is at great pains in Section 4 to tease out what specifically is Kenya accepting in the Rome Statute is very critical.
Not
It isn't. Yes. That's the point, Mr. President, that I'm coming to. In these general terms, the draftsman then goes to the body of the act and deals with each aspect of what Kenya has accepted. The enforcement of Part 6, which is, relates to the conduct of the trials, is accepted in terms of the detail that is set out in the Act, not independently of the statute. There isn't something that can be inferred from the Rome Statute in general terms that conflicts with what appears in the International Crimes Act in specific terms.
Mr. Attorney, we have to leave it there for now. We will return at 2:30 from the lunch break. We've given you a lot of time because we don't often have you with us, and
I appreciate
and we need you to also help us with questions pertaining to the law of Kenya. So we might as well get as much out of you as we can while you're here.
I appreciate
Thank you. We will rise and come back at 2:30.
All rise. All rise. We will lever. Please be seated. We will swap.
Thank you very much. Welcome back, everyone. Mr. Migai, you are on your feet, I believe, before the luncheon break. And I believe we were discussing the issue of to what extent the Rome Statute forms part of the law of Kenya. Yes. Now, before we proceed, there is a matter of procedure I thought I should bring to your attention. I'm sure you and I have made the work of court reporters very difficult because we've been talking at more or less crossing the wire on the microphone, and it makes the work difficult. I realize that when you're in full flow, it's difficult to stop, but I have right of way, you see, not because of the formalities of the courtroom, but because you have to persuade the chamber. So if there are some questions that we have, these are questions that are troubling us that we'd like you to answer. And one of them is the implication of Section 108 of the ICA. And I asked that in the context of whether or not, I mean, this is a discussion we picked up before lunch, whether or not the ICA is exhaustive in the types of assistance that it indicates that may be given by Kenya to the ICC. And it takes us to Section 108. And Section 108 comes after a listing of, or heading of, all other types of assistance. That the court may request, and ends up with the provision in sub 1 where the ICC requests any other type of assistance. Under paragraph 1L. And paragraph 1, under paragraph 1L of Article 93 of the Rome Statute. So here we see paragraph 1L coming in of Article 93. It comes in after paragraph, is that 1E? One that talked about voluntary assistance, is it? It says any other type of assistance. Does it not tell us that assistance beyond voluntary attendance of a witness may be requested by the court.
My own reading of that, Mr. President, sir, would be 108 is trying to provide a domestic framework for the implementation of the obligations under Article 93(1)L. A very narrow, very, very narrow. And this is what we called earlier in the morning the residual jurisdiction. The draftsman of the treaty spends a lot of time enumerating what kind of cooperation would be required. And at the end of it, L is a catch-all, and it is intended, in our view, to ensure that these categories of cooperation are not exhausted. We do not believe that it is intended, where there is a specific provision, to expand that specific provision. And that's why it says, I think, 1081 says, 1081B, the Attorney General shall give authority, B, if he is satisfied that the assistance sought is in accordance with Kenyan law. And therefore, irrespective of any assistance that may be sought by any other person, the Attorney General must be satisfied that it's in accordance with Kenyan law. Indeed, if I were the prosecutor, I would not invoke this sort of provision, because it actually limits more than expands. It then creates a bottleneck where the Attorney General, without reference to any other body or authority, is the judge of whether the request has complied with Kenyan law. If I were the prosecutor, I would perhaps stay with a straight and narrow, which is to say, facilitating the voluntary appearance of persons as witnesses or experts before the court. That one is clear, it is unambiguous. The Attorney General doesn't have to satisfy himself anything if it is clear that the witness has volunteered to testify.
Yeah, but yes, we know that voluntary assistance, voluntary attendance, it seems from the prosecutor's written material, is out of the question because the witnesses have said they are not coming anymore. So they will not be requesting voluntary attendance from someone who does not want to come anymore. So they now have to find a way to bring the witness if they feel that the witness's evidence is material. And then Mr. Khan raised an important question which the prosecution would have to address in their reply on the matter of why do we want to do this if the witnesses had already indicated that they had recanted their story. That's a separate matter. But here we see a listing of assistance or instances of assistance, including the section 87 you mentioned, and then all the way through 90, through 100, and then 108 talks about any other assistance.
Yes.
So he would have already, 108 would have already taken into account, does it not, Article 87, sorry, Section 87 I mean,
Yeah.
that had been invoked repeatedly by both yourself and by Ms. Bosman, when he says any other kind of assistance.
If the, let us assume, Mr. President, that we were exchanging communication with the prosecutor, and he wrote to me and said, I would want assistance under Section 108 of the ICA to have the following witnesses appear in Nairobi at a given forum in order for us to take testimony from them. My simple and clear answer would be Section 108 does not and was never intended to cater for the request that you are making. I believe that you invoke Section 118 in order to avoid the very clear legal requirements of 87, 88, 89, and 90. Please satisfy those requirements, and we would be more than happy to assist you. That would be my answer.
Is Section 108 not consistent with the theme we picked up in Section 20 and Section 23? Remember, Section 20 is the section that says nothing in that section limited the types of requests that the ICC may make, and nothing in that section would prevent the rendering of assistance to the ICC as they may request if it was not prohibited by Kenyan law. So you see that 20?
I do, sir.
And then 23 talks about, again, what may be done if there is a procedure in place. Follow that procedure. But if there is no procedure in place, make your best efforts to comply with the request. And then here we see the same theme picked up in 108. After listing all kinds of specific assistance, provision says any other assistance may be requested. See the trajectory that I'm getting at.
I think I have understood the point of departure. And maybe I should make two clear points. Point number one. We lawyers speak of the letter and the spirit of a statute. In my view, good lawyers start with the letter of the statute. Where the letter of the statute speaks for itself, you do not have to harvest any spirit of the statute. In this case, it is our submission that the clarity of the black letter law is such that we have no reason to depart from it to investigate the penumbra, as you recall Professor Hart taught, the penumbra of the rule, because the rule is so clear. That is one doctrinal issue, and I hope we have laid it down. Number two, I think that it is also important to make the point that where a rule of law is specific, very specific and clear, the clarity of its specificity cannot be taken away by the generality of another rule. Let me give you an example, Mr. President. In domestic law, in procedural statutes, there will always be a general catch-all that says, no, notwithstanding everything set about us in this statute, nothing will diminish the power of the court to do justice, substantive justice. A lawyer who comes to court and says, I am looking at the Criminal Procedure Code or the Civil Procedure Code, but I find no basis for my application in law, but I want the court to use its general powers to do justice. In my own view, that would not be a good lawyer. what law can do is set by Parliament. Lawyers should not be creative to find within law that which the legislature has not provided for. I want to repeat, therefore, the argument, Mr. Chairman, sir. The Rome Statute was debated at great length, and I have been presumptuous enough to bring this article by this very distinguished professor, who I would like to believe that, Mr. Chairman, you are familiar with, Mr. Joran Slater, Professor of International Law at the University of Amsterdam. He makes this argument so eloquently that these issues were debated at great length, and then they were abandoned for lack of consensus. For you, Your Honor, Mr. President, and this court, for you to write into this statute what was rejected at the Assembly of State Parties would do a great disservice to this court.
It would be, I think it would help us more if we had provisioned in the statute itself, actually, that says that the court may not do X.
Aha.
It's better, it helps everyone better than an academic article that was written before the court actually confronted a question to deal with it. So if you have any provision in the statute, or even the laws of Kenya, that's my trouble here, I'm trying to constantly come at. The provision that clearly says the court may not do X, then please bring it to us so we can read it, either in the Rome Statute or in the ICA. That would be very greatly helpful to us. We need not go to the extent of the maxim that whatever the law does not forbid, it allows. There's a maxim like that, as you can remember, but we need not go that far. Right now, if we can limit ourselves to a clear, what you call plain letter of the law, that says this shall not be done by the court. And this is important because one interesting position we found ourselves with in this court, and of course it makes, people may make what to think of it, is we find that when it suits one side, they tell us, you have all the discretion in the world to do something, but then you'd be surprised the next day when it doesn't suit them on something else. And no, you don't have the power to do anything. So here we are. You remember the excusal debate we had? That was part of it. So here, if we have a provision that clearly says, no, you don't have the power to order a witness to come to court or make a request of a certain kind to a state party, that will help us more than academic articles written before the chamber has actually had a live case and had debate from so many lawyers on this question, on the matter.
I want to say this, Mr. President. We must warn ourselves of the danger of creating a false dichotomy. What we write in law on the whole is what can be done. And that is why 93 is a very exhaustive provision in the treaty. It says the state parties shall cooperate in this way: identify, take evidence, question, serve documents, facilitate.
And it ends with the L.
And ends with the L.
L.
It is very unusual, in my experience, for a statute to dedicate itself to what cannot be done. Because the limit of what cannot be done, the permutations are they are unimaginable at any given time. We in Kenya did not write the International Crimes Act to say what will not be done by the court or by somebody else. We wrote it to say what will be done. So if you ask me, as you have, show me where it says you can't do it, I say I can't show you because that wasn't the purpose of our statute. If you ask me, show me where it says what you can do, that's what I've shown you. 86, 87, 88, 89, 90.
And 108.
Yes. And yeah, very good, sir, that you brought me to 108. Let's look at its heading. Other types of assistance. The draftsman could not have been clearer. The draftsman is saying, I have set out extensively specific instances of the obligation of the state, and goes on and on and on and on and on, and then says, if I have forgotten something, other types of assistance. Let me then suggest this to you with tremendous respect, Mr. President. The obligation that you now impose on me is an obligation that lies squarely in the hands of the applicant. The applicant must convince you that they have exhausted the very clear, specific, and detailed statutory procedure and therefore have become entitled to a fuzzier, secondary, indeterminate, controversial procedure. That's their duty, not mine. My duty is a simple one, which is to say, I have shown you everything that the statute demands me to do. I cannot show you things it doesn't demand me to do because it is not written to exclude. It is written to itemize. So my simple answer is this. The government of the Republic of Kenya cannot and does not believe it is under an obligation to demonstrate that there is an impediment to the execution of a secondary request where the primary one in the first place has not been made and has not been demonstrated to be deliverable under the specific law. Let me put it differently. 108 cannot be a refuge. It cannot be a refuge for a prosecutor who is manifestly unable to bring his case on a long, clear, well set out provisions of the law. So, even if this court were desirous of doing justice, of being fair, of doing equity, of doing all the great things we like to see done, they must be done in accordance with the law. And if the law, as it is our submission, is very clear, it says, do this, do that, do that, do that. And the prosecutor says, I have been unable to do what the law says. Please find for me somewhere a spirit, some woolly, some fuzzy, find me refuge there. It would be a very unhappy day. And I can tell you this, my Lord Chairman, Mr. President, I can tell you this with your permission. It would come to haunt this court. It would open a Pandora's box that would never shut. Because the treaty...
It isn't woolly because 93L says what it says. It does not woolly. It says any other assistance apart from those listed already from A to K may be requested. So it isn't woolly as if there is no legal basis for it.
It is woolly where it says in L, any other assistant which is not prohibited by the law of the requested state. Now, what is not prohibited in the law of the requesting state is not something to be determined by the prosecutor. It is to be determined by the receiving state. We in Kenya are masters of our own jurisprudence. What does our law say? What does our law compel us to do? We, with tremendous respect, submit to this court that we are the judges of that.
But it's not that simple, though, is it? And the reason I say so, if you look at 93(1)(L),
Yes.
it is in fact an unusual provision in international law in the sense that it is telling a state party, you may rely on your local law to refuse to perform what may be characterized as an international obligation. Now, that is what makes it unusual. The usual thing in international law is that a state may not rely on a local or domestic law to defeat what may be an international obligation. You know that.
Yes.
So here we have the generosity of 93(1)(L) saying any other assistance that is not prohibited by the law. Why does that become something that may not be requested? It will be a bad day, and you do not encourage the court to go through that route.
Absolutely.
Yes. Why?
Let me say this. From where I sit, my interpretation of what is not prohibited by domestic law is this. As the Attorney General of the Republic of Kenya, invited to act in a manner that calls me potentially to compromise the rights of a citizen of the Republic of Kenya, then I say this. If the statute doesn't expressly ask me to do that, it prohibits me from doing that.
Now, the right of a citizen of Kenya, for you to make that argument, you need to convince us that the laws of Kenya would not permit a citizen to be compelled to appear in any court. We begin with that.
Yes.
The laws of Kenya do not permit compellability of any witness to appear even before the Kenyan courts. Then we're getting somewhere.
Indeed.
Right. Short of that, I mean, once you've overcome that, then the next obstacle is where the law of Kenya says that a citizen may not be compelled to appear before the ICC. Do we have any or both?
2 points there, Mr. President. Number one, the entire constitutional law jurisprudence of Kenya is founded on a very simple principle. Where the coercive powers of the state may be used against a subject, a citizen of Kenya, it must be on the basis of a clear law, clearly set out by the legislature, empowering that organ or that officer of the state to do so. Under Kenyan law, we cannot compromise, and whenever you take the liberty of any person, even so that he may testify in the tribunal, any tribunal, you have taken his liberty away from him. You have taken the right for him to be where he would have been otherwise. It cannot be by inference that we shall do that.
Yeah, but it's not by inference, is it? When Section 4 says that the Rome Statute, in the listed part, including Part 6 of the Rome Statute, shall have the force of law in Kenya.
It does.
So that is the force of law in Kenya.
Yes.
If we now plug into that,
Yes.
Part 6, in its elements that includes Article 64, 6B, which you have, at least to some extent, and I believe Mr. Ruto's counsel have gone perhaps further, I don't know,
No problem.
to agree that it can involve making an order, a compulsive order on a witness in certain circumstances.
First, I think that gives me an opportunity to raise another doctrinal question, which is, seems to be an assumption that the Rome Statute and the International Crimes Act have a special place in the hierarchy of Kenyan law. Let me discourage that notion, because they do not. Under the constitutional law of Kenya, all statutes, all of them, lie below the Constitution of the Sovereign Republic of Kenya. And no statute, no matter this very important statute that we ourselves joined voluntarily, or indeed any other, including the Universal Declaration of Human Rights, including the UN Charter, nothing overrides the Constitution of the Republic of Kenya.
And I think that is recognized in 93(1L, isn't it?
Yeah.
That is already,
that's right.
It's implicit
Yes.
in that. So the question then becomes, what does the Constitution of Kenya then say, which defeats the prospect of the request to be made to the government of Kenya?
That's right. Let me read for you what the Constitution says in the Supremacy Clause, which is Article 2.6. Any treaty or convention ratified by Kenya shall form part of the law of Kenya under this Constitution. What does that mean? First, under this Constitution, meaning the Bill of Rights of the Republic of Kenya, securing, and I am about to read that for you in a moment, if I should go there, all the rights secured for the individual in Chapter 4, Part 2 of the Constitution, the right to life, equality and freedom, human dignity, privacy, freedom of expression, freedom of association, freedom of political rights, and so on and so forth, fair administrative hearing, access to justice. These are the fundamental juridical norms that govern the Republic of Kenya. If there be a law, or any treaty, or any convention, or any judgment of any tribunal that compromises those principles, the government of the Republic of Kenya would be invited, therefore, to determine whether it will obey the Constitution or it will obey some other.
But you've not been put in that position at all.
I would hope we never get there.
No. You have not been put in that position because Article 93(1L) does not put you in that position. It says any other assistance that is not prohibited by the law of Kenya. So it is now for you to say, yes, the assistance that is being requested or that is being contemplated is forbidden by the Constitution of Kenya in these terms, and then you read out the specific provision of the Kenyan Constitution that says, no, this cannot happen. That's why we invited you to come and help us.
Good. First, let me say this, and I think I'll be repeating myself, but it probably bears repeating. In my own understanding of the law, where the government of the Republic of Kenya enacts a law through its parliament or through the conclusion of a treaty, and where that law creates very clear circumstances in which the fundamental constitutional rights of a citizen of the Republic of Kenya may be abrogated or compromised, there can be no other basis of compromising those rights absence a clear empowerment of an officer or an institution. So to the question you've put to me several times, which is this: show me where it says you can't do it. My answer is, in our jurisprudence, we do not write law to exclude, we write law to include.
That's
So
also,
this statute tells
but
me,
yes,
if I may,
yes,
if
you
I may,
said that. Do I then take it to mean that there is no provision in the Constitution of Kenya that excludes that? I mean, that's a simple question.
that excludes what?
Excludes the type of request that is contemplated in the prosecutor's application.
If you're asking me, Mr. President, does the Constitution of Kenya address the question of whether a tribunal, an international tribunal, having made a request about a witness to be brought to Kenya, to have his testimony taken, can or cannot be compelled? The answer is no. I do not know of any country in the world that would write such a rule in the Constitution. And let me finish this, sir, if I may. I don't even know of any country in the world, and I would challenge my more distinguished and learned colleagues here, to tell me by their own research and endeavors, any country in the world that has domesticated the Rome Statute, yes, and that has then set up a category of a section that says the following acts are not prohibited and the state is at liberty to enforce them. There is no style of drafting of that nature in the world. That is why the discretion in 108 is my discretion.
All right.
Yes.
Now, we've established that the Constitution of Kenya doesn't exclude.
And I don't know of any in the world that does.
But what we do know is what you've read out now, the Constitution saying treaties ratified shall form part of the law of Kenya. We also know that Section 4 of the ICA says certain parts of the Rome Statute shall form part of the law of Kenya. When we have that in place, and we have a provision like Article 64(6)(b), which says the chamber may require attendance of a witness, on what basis do we then say that that sort of request is not accommodated by the law of Kenya in the absence of clearly excluding language? That's my dilemma.
Right. I think we have misunderstood each other, because I thought the question you were asking me is, does the Constitution of Kenya speak in specific language to the question of what is to happen in an instance such as we confront, where an application is made for evidence to be taken from a witness? And my answer was, the Constitution of Kenya is not a procedural statute.
That wasn't my question.
So now let me answer your question. The Constitution of Kenya does. It does create fundamental norms that preclude the exercise of arbitrary power by government officials. And the Attorney General is a government official. The Attorney General of Kenya cannot exercise arbitrary power against a citizen of Kenya, then say, I have no specific law that allows me to hold you incommunicado. However, there is no specific law prohibiting me from doing so if the request is from the ICC. This is what the Constitution of Kenya says, Mr. President, sir. Freedom and security of the person. Every person has the right of freedom and security of his person, including the right not, A, that's 29, Article 29A, to be deprived deprived of freedom arbitrarily or without just cause.
Mr. Mugai, you see, we have to move on. It looks like keep looping back into notions that extend the debate. You're now invoking arbitrary action. I don't know how we can say arbitrary action when there's provision that we've been reviewing all along what they mean, and whether ICC is part of the ICC statute is part of the laws of Kenya.
Absolutely.
So,
Subject to the Constitution.
so the point about arbitrary doesn't come in. But let's move on. One point you make in your written submissions is that whatever think you made that point,
Yes.
in the context of the reading of the word require, its meaning within Article 64, 6b, and you say we need to go back to Article 31 of the Vienna Convention on the law of treaties.
Yes.
You remember that?
Yes.
And naturally, that also goes, I take it, for any other provision in the statute, including what to make of Article 93. So we go to the Vienna Convention on the law of treaties, Article 31 of it.
Yes.
Right. And the provision is, quote, which you set out in your written matter.
Indeed.
A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in that context and in the light of its object and purpose. Unquote.
Absolutely.
You make that point.
Yes.
So there we see four notions, I believe, that are implicated in the provision. One, the notion of good faith. Right. What does that mean in the context of a criminal trial? The search for the truth. How does that throw light on the interpretation of the word require as the word is used in Article 64, 6b?
Let me come to, may I? First, I welcome the opportunity to discuss what the Vienna Convention on the Law of Treaties means for these proceedings. We are a treaty body. This chamber, this court, is created by a treaty. This treaty is negotiated by independent sovereign states. In the course of that negotiation, those sovereign states consider various possibilities, advised by eminent jurists, like some of those in this court today. If they make, or I cannot think of a more eminent person than my friend the prosecutor, and so I mean that as well. But what I meant, Mr. President, is that Article 31 of the Vienna Convention is telling us a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its objects and purposes. I would imagine that even the most creative jurist in this courthouse admits that this treaty speaks in the clearest possible language about the voluntariness of the testimony of witnesses.
They
There's
do
no
not,
doubt about that.
no, they don't agree with it, and that's a question to be determined still. So let's not assume it.
Well, I thought that was conceded, that as a fundamental principle of the treaty, it is anticipated that witness will appear voluntarily. Shall we call it the general rule, then grant them the exception they are trying to create now?
The general rule, indeed.
The general rule is that witness will appear voluntarily. That is the spirit of the Vienna Convention. We must give the treaty its clear and ordinary and unambiguous meaning and interpretation.
We're beyond that. We're beyond that. We're beyond that. We're now in the stage where there is no question of voluntary appearance anymore. The question is, can a witness be compelled? That is the question. So let's lead ourselves to that
And the answer.
and see what the concept of good faith invoked in not only Article 31.1, but also Article 26 of the Vienna Convention on the Law of Treaties. Say, what does it mean in the context of the search for the truth, where the witness refuses to voluntarily appear in the search for the truth? Remember in the beginning I cited you and your eminent credentials as a chief law officer, and if this trial were happening in a national jurisdiction, a witness says, I do not want to come in the search for the truth in a criminal inquiry. What should be done in the context of a provision that says trial chamber may require attendance of a witness in the courtroom?
Let me first say that in the context of the Vienna Convention in Article 31, I would like to remind the honorable judges, the Vienna Convention is speaking to the obligation of states. It is speaking to the obligation of states, and my Latin is not very good, but I believe it is Pacta sunt servanda.
Pacta sunt servanda. Yes.
There you are, my lord. You are a more learned man than myself.
No, I'm not.
But I am obliged by the correction. It is you are bound by your undertaking, by your commitment. It is the state. We are in a very difficult situation where we are talking not about the obligation of the Kenya government per se, but the rights of a citizen of the Republic of Kenya that are independent of the state and to a very large constitutional extent cannot be compromised by the state. If the government of the Republic of Kenya went and negotiated a treaty that said we will never require any extradition requirements, any country in the world can write us a letter and say we require Mr. Odede, that treaty would not be worth the piece of paper it is written on. Why? Because the rights of the citizen of the Republic of Kenya are so fundamental that they would trump in a contestation the clearly unconstitutional treaty. And in international law, as all the jurists here know, it is the responsibility is a responsibility of the government. It cannot be the responsibility of the citizen. We cannot.
In a domestic criminal trial, let's say there's a robbery or a murder, and a witness that a DPP or the prosecutor wants to call, insistent calling, says, sorry, prosecutor, I'm not coming to court. Does the Constitution or the Bill of Rights authorize that witness to stay away and not be compelled to appear?
You have invited me, Mr. President, to compare oranges and mangoes. A prosecution under Kenya's domestic law in enforcement of Kenyan law is a completely different thing. And I know in the morning you alluded to the International Court, Criminal Court being a Kenyan court. That is metaphorical. It is not juridical. Kenyan courts are set out in the Constitution. The Constitution says clearly the Supreme Court, the Court of Appeal, the High Court, and the subordinate courts. There is no reference to the ICC
But it
or
does
indeed
say,
the ICJ.
no, but the Constitution says that every other treaty
Yes.
that has been ratified is part of the law of Kenya.
Yes.
So the Constitution need not mention the ICC, does it? If it says any other treaty ratified shall be part of the law, and the Rome Statute has been ratified.
Yes, yes.
And the Rome Statute is the enabling body for the ICC.
Well, the simple and direct answer to you is that that does not make the ICC a Kenyan court. I doubt that judges of this court would like to be referred to as Kenyan judges.
I
Or the
don't mind.
prosecutors
Speaking for
that matter.
myself, I wouldn't mind that at all. But go on.
This is a court that is recognized by the law of the Republic of Kenya as a court that has a limited jurisdiction. May I add, a very limited jurisdiction in its application to the Kenyan state and the Kenyan people. And that application is confined to the trial of war crimes and crimes against humanity. Now, if you've ever looked at our penal code, we have more than 300, 400 criminal offenses. So to call this court a Kenyan court for purposes of that would be inaccurate. It's a Kenyan court in a metaphorical sense, the way the East African Court is, the way the African Court of Justice is, the way the International Court of Justice is a court that Kenya ascribes to by treaty. So let me come back to the last point and state this. The Constitution, the application of the International Crimes Act in fulfillment of Kenya's international treaty obligation as contained in the Vienna Convention requires me to keep asking myself what was the context and object and purpose of the treaty. And may I tell you, my Lord Chairman, Mr. President, what my answer is? The purpose of the treaty was to create a fair, independent, impartial tribunal that would effect justice in matters of international criminal law as defined. Further, that jurisdiction being a limited jurisdiction, the statute is permissive. The statute was intended to show under what circumstances you can do something. For the Attorney General or the DPP or the Minister of the Interior to arrogate themselves extra penumbra powers by saying, I have looked at the International Crimes Act. Nothing says I cannot send you to The Hague, at least until Monday. I know they will come back. The prosecutor told me he will send you back. And the victim, and this is a real victim then, and the victim asks me, why would you do that? And I said to him, show me something that says I can't do it. This is what law, this is why the Magna Carta was written, that all these plenary powers of kings and unaccountable individuals should be subordinated to law. If this court was invited to find that we have opened a new era in which the Attorney General or the DPP or a minister says, anything not prohibited in this law is permitted to me. And right now, I think I would like to smack your face. Show me something that says I can't do it. It would be preposterous.
Hold on. Of course you can. It's up to you if you want to say that. That's one answer you can give. And no one. But then it is another law officer, chief law officer, may not, may she not, take the view or reply to the witness that we have a constitution that says the Rome Statute is part of the laws of Kenya. And we have Section 4 of the ICA that says the Rome Statute in certain sections is part of the law of Kenya. And within that is a provision that says the chamber may require the attendance of witnesses, and that provision is in Article 64(4)(b). It is on that basis. Power is not arbitrary. It is part of the law of Kenya to the extent that the Rome Statute is part of the law of Kenya. Is that not an answer that can be given by another law officer who chooses not to make the argument that whatever the law does not prohibit, it allows?
It is not usual in a forum of this nature for counsel to ask a question, but I probably would ask, what is this that is not prohibited?
That which Section 20 and Section 24 of the ICA and Section 108 of the ICA say, which are any other requests for assistance that have not been specifically itemized, may be made. And that might include request for compelling a witness to attend.
It would not. And I want to repeat myself and make myself, I would hope, absolutely clear. This statute commences by itemizing, and you were quite right when you drew our attention to Section 20. It itemizes what it intends to legislate about. Then the draftsman spends a lot of time detailing, if you want a witness to appear, look at 80. If you want to serve a document, look at 86. If you want a witness to appear, look at 87. If you want assurances, look at 88, and so on and so forth. The draftsman has such clarity. And what I have been saying, which probably bears repeating, is that Section 108 was not intended to reopen the express. The draftsman is saying, if you want a witness to appear, I have discussed that exhaustively in 86. There can be no legitimate reading of the statute that would make other types of assistance, other types, meaning you have already exhausted assistance, what assistance is. You have now come to create a general provision just in case you have forgotten something else. So an argument that says, can I not come under 108 to find some authority to summon witnesses who do not wish to be summoned? My simple answer is, how can you? How can you seriously want to say that? Did you not see Section 86? Or did you not see Section 87? Bring yourself within the ambit of 87. Because what you are trying to say then to the court in that situation, you would be saying, the truth is that I know that there is a very clear provision of Kenyan law. I know that. I also know that I am unable to abide by it. I am unable to. Therefore, please find something else, somewhere for me to hook my wagon. That is bad jurisprudence. I do not want to use a stronger word that would go to impeaching motive, but it wouldn't lie in the mouth of the prosecutor. Let me leave it at that, and just say
While
this.
you leave it, let's move on. We still need to exhaust what's Article 31.1 of the Vienna Convention says, and you've taken us to the concept of context and purpose, and you've defined context and purpose in terms of what the ICC was meant to do, the statute. Is it the case or not that the preamble to the statute is perhaps the most compendious expression of the purpose of the statute? Objects and purpose.
Yes.
Of the statute. You agree? So we look at the preamble now, if we may.
Yes.
First 5 paragraphs. First paragraph, conscious that, interpreters can turn to the French version, of course. Conscious that all peoples are united by common bonds. Their cultures pieced together in a shared heritage, and concerned that this delicate mosaic may be shattered at any time. Mindful that during this century, millions of children, women, and men have been victims of unimaginable atrocities that deeply shock the conscience of humanity. Recognizing that grave crimes threaten the peace, security, and well-being of the world, affirming that the most serious crimes of concern to the international community as a whole must not go unpunished, and that their effective prosecution must be ensured by taking measures at the national level and by enhancing international cooperation. Determined to put an end to impunity for the perpetrators of these crimes, and thus to contribute to the prevention of such crimes. Let's stop there.
Yes.
These are lofty aims, are they not? Object and purpose of the Rome Statute. How do we begin to hope to achieve these ends if people who may shed light on the truth, on the inquiry rather, in the search for the truth, say, no, we don't want to come, and then we say, that's it, that's the end of it? How do you begin to hope to end impunity?
My Lord President, Mr. Chairman, the poetry of the statute is very important. It is intended to remind us of the commitments that we have made as a civilized humanity. I'm sure when you find the time in your deliberations, you will read the preamble of the Constitution, of which I am part draftsman. It contains the same exact poetry, which is fundamental, because it is intended to remind us that the things that have gone wrong in our various experiences should never be repeated. But nothing in the poetry that I wrote in the Constitution of Kenya affects the way I shall construe the right of a prisoner in a Kenyan jail. I am mandated in very clear terms to act in accordance with the Prisons Act of the Republic of Kenya. And where it says I will accord the prisoner 6 hours of sunshine and I will give him a good diet, I will not be able to answer him by saying, show me where it says you need protein once a week. What we are saying, Mr. President, is that the lofty ideals of the treaty are conceded. The work that this court is doing, if we thought less of it, we wouldn't be here. We think highly of what this court is doing in its search for justice. We are only asking this court to confine itself to law. And we are warning, sorry, that's a strong word, we are cautioning that should this court allow itself to be seduced down the road of reading more powers for itself, arrogate more powers for itself, two things will follow as night follows day. The number of state parties willing to join this court with an indeterminate treaty whose meaning is not known by anybody, whose meaning is created by the court in an experimental way from case to case. I don't know of a state that has not signed on the treaty that would sign on that basis. Say, what are we signing on? And the lawyer advising the government will say, we are not quite sure because the court creates its jurisprudence as it goes along. Shall we be required to surrender our soldiers who have fought in a neighboring country for an act of war? We don't know. It is unclear from the statute, but the court probably would want to exercise that extra power as well. We would strongly discourage, as a state party, that the court should go down this road of adventure.
Mr. Mugai, moving on, there's another line of question that I have, but before I do that, there was in his submissions, Mr. Stewart said that there is an injunction that prevents any judge in Kenya from acting as, I used the expression before, rogatory commissioner, you know what I mean, the judge that takes evidence in Kenya from the ICC. Is that the case?
There is an inaccuracy there because that was a specific proceeding. Those were specific proceedings and they related to specific individuals in a specific context. I think the most important thing to remember there is that these were proceedings before these cases were commenced. So they were in the nature of investigations. There was not a prosecution. And therefore there is a big difference.
Oh, right. So then what you're saying is that Article 93, 1, is it B? I think it is, that contemplates taking of evidence under oath. It's still possible. Is that the case?
Sorry, I missed that question. If you could be as kind as to repeat it.
I'm asking you whether it is the case that the taking of evidence under oath pursuant to Article 93, 1B of the Rome Statute is still a possibility. Is that what you're saying? That there is no impediment to that kind of assistance being rendered. Is that the case?
Subject to the Constitution and the law, which is what we've been debating. Subject to the Constitution and the law. If, as I have demonstrated, that this can be done subject to compliance with the International Crimes Act, the answer is yes, subject to compliance.
Let's do this. Could you kindly, 1 second. So you don't it may not be that I did not want to put you in a difficult position now of making commitments and answering questions on that point. Could you kindly, could 7 days be enough time for you to write back further submissions to the court on that specific question, whether or not there is an impediment, a legal impediment within Kenya to execute requests pursuant to Article 93(1)(b) of the Rome Statute. When I say legal impediment, that includes the claim made earlier that there is an injunction that forbids it, and to any other law, the Constitution or any other law in Kenya that says this may not be done. Can you, in 7 days, write back to the chamber on that?
That would be very difficult because, Mr. President, sir, Article 96 is very clear. It is Article 96 that makes it possible for us to understand the nature of the request. And Article 96 says this: the contents of a request or other form of assistance under Article 93. A request and other forms referred shall be made in written and so on and so forth. The request shall set out the following. So the hypothetical is very difficult for us to respond to unless there was a specific that is set out in 96.
No. 96 is about other forms of assistance. But here 93 specifies Article 93(1)(b).
No, sir, I beg to differ. 96 says clearly the contents of the request of other forms of assistance under Article 93 in its generality.
93, 1L.
The whole of it.
1L.
The whole of 93.
93, 1L is the one that speaks of other forms of assistance, isn't it? So
no, sir. Article 96 provides a procedure for all applications under 93.
Anyway, we need not belabor the point. I was wondering whether it might be more efficient for you to write back and say...
Yes, I can write back and repeat this.
You don't need to read. That's all you're telling us. Then that's the extent of it. The question would have been whether...
If
One
what...
second, please. The question would have been whether the laws of Kenya, either in terms of an order of a court, or specific provision of the Constitution or other law, would oppose an impediment to taking commission evidence under 93(1)(b). So if you're not in a
the
position
difficulty,
to do that, then we'll leave that.
The difficulty, Mr. President, sir, is that actually the question you have posed has created the matter, has abstracted the matter more, because the prosecution's request is very concrete, and it is this: we want you to take evidence from persons who used to cooperate with us, who have now refused to cooperate with us, who have said they will never cooperate with us again. So that is very, very, very narrow and very, very specific. If you asked me to elaborate on our response as to whether in those who have now refused law, because in Kenya we ask ourselves, is there a basis for doing this? And where there is no basis, we will not act in a manner that is inconsistent with the law. If you're asking me, Lord Chairman, Mr. President, if you're asking me to respond to that narrow question, that would the Kenya government have a difficulty executing a request that said, go and find these people? Remember, Mr. Chairman, sir, I don't know these people. but I assume that can be overcome if the prosecution allowed me to know. If the question was, would there be a difficulty on the part of the Kenya government finding these people, putting them in a chamber, compelling them, meaning finding a law in Kenya that allows me either to send them to jail until they give the statement, or to fine them, or to take their assets, or to some other penal process that compels them to, I would be happy to respond to that question.
All right. I mean, it's simple, Mr. Mugai. See, the reason why Article 93, 1B, enters the picture is this. Article 93, 1B is a specific provision in the Rome Statute. It is not a matter of Article 93, 1L, that is a catch-all. Article 93, 1B, in its own standing, enjoys the same separate, distinct standing as Article 93, 1E, that you like very much. So if 93, 1B says evidence may be taken by a Kenyan judge, remember, the prosecutor had said they would like the chamber to either do this, implement their request by way of a video conference with a witness in Kenya, or the chamber goes to Kenya to conduct proceedings and receive the testimony of these people. And you are saying, your response is, that cannot be done. It doesn't matter whether the court comes to Kenya to sit, or the court is sitting in The Hague, that the Kenyan government, your position is that the witness may not be compelled to attend. Now, that was your position. And here we have 93.1b that specifically says it is a duty upon the state as part of cooperation to receive requests about taking evidence. And the ICA recognizes that, I believe. Not I believe, because if you look at the rules, the ICA rules, if you look at the ICA rules, the rules on the ICA, from Rule 4, specifically Rule 4 and Rule 8, provide rules for this sort of commission evidence to be taken in Kenya. It is part of the ICA. If that can be done by a Kenyan court sitting in Kenya, why would it be difficult for the ICC sitting in Kenya to not be able to compel a witness to testify when a witness can be compelled to attend a rogatory commission conducted by a Kenyan judge? It is there that I want to find a difference. We are trying to figure out what good faith means in the context of the Vienna Convention, the law of treaties, in this matter. Why the difference?
I am not sure that it is considered by us that there is, that if in Kenya we constituted a judicial panel and gazetted it, or the Chief Justice undertook whatever measure, that a Kenyan court would compel the witness on behalf of the ICC to be present in the Kenyan court. It would not.
All right, let's not speak hypothetically. I'll read the text in question. Rule 4, do you have it, the ICA rules? Rule 4, and I'll quote, the International Criminal Court may make a request.
Hang on, Mr. President. I'm trying to check it in the bundle that has been supplied here. First schedule, yeah? Sorry, Mr. President, just read it.
I can read it. Rule 4. The International Criminal Court may make a request to the Attorney General for the taking of evidence and production of documents in relation to an investigation by the prosecutor or to any proceeding before the International Criminal Court, unquote. That's Rule 4. And Rule 8 says,
Yes, go ahead.
before I go to Rule 8, because it makes reference to Rule 7, Rule 7 says, provide for forwarding the request. Upon designation of a judge under Rule 5, the AG shall forward the request received under Rule 4 together with the particulars of the intended witnesses or documents to the Chief Justice, who shall promptly transmit the request to the judge, unquote. Now, you go to Rule 8, provides 1, on receipt of the request under Rule 7, the court shall issue summons to the intended witnesses together with a summary of the issues upon which any intended witness is requested to testify on. And 2, where the request relates to the production of any document, the court shall issue summons to the person in possession of the document or who has authority over the document, requiring him or her to appear and produce the document. And here's a crucial part, sub 3. The summons shall be served on the intended witness personally, and there shall be a period of 15 days between the date of service of the summons and the date any intended witness is required to appear. So we have rules intended to service what is contemplated by Article 93 1B. My question is, if this can be, what is the material difference with saying an ICC cannot come and sit in Kenya and take this evidence itself directly?
Mr. Chairman, Mr. President, the confusion that is arising is partly caused by the fact that I have been responding to the application as framed by the prosecutor. And as I understand it, the prosecutor is not interested, and I'm not inferring. He said so in clear language. He said, I do not wish and I am not interested in a process that anticipates a Kenyan court or tribunal being involved in this process, unless I misunderstood him.
So that's
the
not
hypothecation
my issue. That is not my issue, Mr. Mugai, Mr. Attorney. The issue is not to force the prosecution, and they will respond, to go through Article 93(1)(b). The question rather is, your position is that the prosecutor says, well, they are not requesting for witnesses to be compelled to appear in The Hague. They want them compelled to a certain location in Kenya so that the video examination may be done by video conferencing, or the chamber will convene in Kenya and hear the testimony of the witness in situ. My question is, and you're saying, no, that is not allowed. So
On the
as
contrary.
long as it's about compelling a witness at all, that's not allowed. But I'm saying here that Rule 4 in the rules, the ICA rules, and Rules 7 and 8, does suggest, does it not, that all that may be done before a Kenyan judge. And I'm saying, if that can be done before a Kenyan judge, why? What is the material difference that prevents it being done directly by the ICC sitting in Kenya, which you oppose?
Let me clarify that, because as a matter of record before this court, when an application was made in this court by the defense, I don't remember which defense, suggesting that this case could be held in Kenya, we filed a memoranda in support. So the support of the Kenya government that the ICC can sit anywhere is a matter of public record. I therefore wish to clarify that at no point have I suggested in my presentation today that the ICC cannot sit in Kenya, either physically or by video link or in any other manner.
That's not the point. The point is about compelling a witness to attend and testify.
I'm coming to that.
before
I'm coming
ICC
to that,
sitting in Kenya.
Mr. Chairman,
Yes.
Mr. President. You have taken international crimes procedure for obtaining evidence rules made under the statute, and given them a meaning beyond what the statute says itself. This is subsidiary legislation of the weakest type possible, in that it has to be measured every day against the statute itself. These rules and the statute must sit together comfortably. What do the rules themselves say? They say this: these rules shall apply where the Attorney General has authorized the taking of evidence and production of evidence under Section 78 and 79 of the Act. What do 78 and 79 do? They create a general discretion on the part of the Attorney General upon a proper application. What is a proper application? It takes us back to where we have been the whole morning. Compellability. I can never imagine a situation in which I would issue a certificate for the taking of evidence without satisfying myself that the specific provisions on the taking of evidence from a witness, which are in 85, 87, 88, have been fulfilled. Nothing in these rules can confer on me a power that I don't have under the main act.
Mr. Attorney, I need to cut you short now. I've cut you. 1 second. 1 second. We've been served notice by the system, the court system, that we will be adjourning at 4:30.
Right.
And the prosecutor has a lot, I believe, on his plate to reply to. So can you wrap up now in 2 minutes?
Yes, and I'm saying this.
And sorry, I do apologize, Attorney General. Your Honour, I beg the Court's indulgence. I would ask that we sit till 5 o'clock, because I tried to honour the timetable that I was required to abide by, and I touched things very quickly. Indeed, there were other questions from the bench that I tried to answer in my allotted time, and I have quite a bit to say. Some issues, with the greatest respect, I have a different position from the Attorney General, and Your Honours, I would ask that time be given to the defence. Hopefully, if we could sit till 5 o'clock, that will allow the prosecution to respond to the Attorney General, and it would give me, on behalf of Mr. Ruto, the opportunity to make what I submit are important submissions that will shed light on this issue. So, Your Honour, I would crave the indulgence of the Court. We sit by 5 o'clock, and so the necessary submissions that have to be made are put before the bench for consideration. I'm grateful. Right.
I also see Mr. you have to make some submissions as well.
Yes, Mr.
right.
President, thank you.
Let's do this. Mr. Stewart, how much time do you think you need to respond?
If you give me 10 or 15 minutes, I'll try to keep within that.
You think you can do it in 5? Key points.
I think I do an injustice to what I want to tell you.
Mr. President, the other option, with your leave, the other option is that I don't know the Attorney General's commitments, but if the court was minded to allow submissions to be made on Monday,
that's what we just conferred briefly on. I think that's what we will need to do. As you know, we did not confine Mr. Attorney to the time frame. The reason being we wanted to ask him all the questions we thought he can assist us with. So he need not be here on Monday. But we can resume on Monday on issue after 4:30 today and deal with any more submissions that need to be made. Mr. Kiginkatwa?
Mr. President, I was requesting that when you are allocating time, you give us some time also.
Yes, we will. As I said, we'll.
Mr. President, I might be forgiven for revising my very limited time schedule if we are going to go on Monday, but I wanted, in fairness to the Honourable Attorney General, simply to point out something that he may need to address. I didn't want to, in reply, address it when he's not here. I think that might not be right. He referred in the International Crimes Act to sections 78 and 79, quite properly in relation to the rules that you were asking him about, but under section 80, there's very clearly a compellability feature to the provisions, and I would be unfair if I remain silent on that. I wouldn't normally have got up to interrupt the proceedings, but I did want to raise that issue. Thank you.
Thank you. So why don't we do this for all of us who are residents of the courtroom, so to speak. We can let Mr. Attorney take the rest of the day, and then on Monday we can pick up the rest of what we need to deal with. So, Section 80.
Mr. President, Your Honors, just a clarification. Initially, I had programmed myself to leave tomorrow, but of course, I would be ready to stay on if.
Senator Ruto, you can stay with us on Monday.
Very well.
If that's not too inconvenient.
All right. Thank you.
Mr. Stewart, what provision in particular are you reading?
Subsections 1 and 2 of Section 80 of the International Crimes Act provides for compellability of witnesses, and I just didn't want to leave that unsaid, because we skip beyond that to the rules, and I would expect the rules derive from that particular provision, at least insofar as a Kenyan judge is concerned, designated to take evidence.
Mr. Attorney, can you please speak to that matter?
May I, Mr. President, before I go to that issue, come to the issue you've raised in respect of Section 78 and 79, and say this. They pose absolutely no problem, because we've already discussed the two very separate cases of a witness who wishes to cooperate. Yes? If I receive a request for the taking of evidence, and a witness comes to me and says, I am very anxious and eager to give evidence, then 78 kicks in, 79 kicks in. It's not a problem.
But we're not, the matter of the witness who wishes to cooperate is controlled by Article 93 1E, is it not, of the statute?
Is it?
Yes. Article 93 1E speaks of facilitating as an assistance you may render.
That's right.
Facilitating the voluntary appearance of persons as witnesses or experts before the court.
That's right.
Now, what about 93 1B, which is a separate matter, is it not? Or is it? The taking of evidence, including testimony under oath, and the production of evidence, including expert opinions and reports necessary to the court. And then here we have Section 80 of the ICA that's talking about Section 78, the taking of evidence. And here's Section 80, talks about questions of compelling a witness to appear for a judge under Section 78.
Yes.
Yes.
First, I want to clarify this, Mr. President, sir. There is nothing in the statute that determines the procedure, and there cannot be. The purpose of the Rome Statute is not to identify how state parties will comply with the obligation. So it is incorrect to say, let us refer to 93B and we will find an answer to how evidence will be taken. We will not. We will find an obligation to facilitate the taking of the evidence. Where shall we find the procedure? In the domesticating law. And therefore, we will come to the International Crimes Act. Where shall we find that procedure? We will find it in 77 and 78. But let us read 77 and 80. Yeah, and I would plead with the court to give me time to make this argument. If you go to 77, it is very clear. The Attorney General shall give authority for the request to proceed if the Attorney General is satisfied, nor any other body or authority. If the Attorney General is satisfied, not if some court or other official is satisfied. A, that the request relates to an investigation being conducted by the prosecution or any proceedings before the ICC. Let me confirm to you that I am aware there are proceedings before the ICC. B, there are reasonable grounds for believing that the evidence can be taken, or, as the case may be, the documents or other articles can be produced in Kenya. Let me break that down into two. I have to be satisfied of two things. Number one, that the evidence can be taken. Therefore, I need to be satisfied that there is a law in Kenya allowing what is said to be requested. I must be satisfied that there is such a law. And let me tell you why, Mr. President. 793B is married to 93E. It is because I have a volunteer witness that I am able to constitute a process of taking his evidence. It is not because that there is some evidence that there will be a volunteer witness. Can I make that clear? Can I repeat it again? Article 93B and 93E, are married together. The way the Attorney General will facilitate the taking of evidence under 77 and 78 is A, by being in a position to identify volunteer witnesses. Number two, let me break 77(2) further. I must also be satisfied that the evidence can be produced in Kenya. This is not about a physical thing. This is not to say that the motor vehicle is located in Kenya. No, the evidence can be produced in Kenya. It's a legal requirement. It's not an evidential requirement. I hope I am responding to that. It is a legal requirement that I must satisfy myself that the evidence can be produced in Kenya. If I am not satisfied that I'm looking at a volunteer witness, if I am not satisfied that there is a reason to do that, then I will not do it. But if I do it, that is when then Section 80 can be relevant. So that there is a process before which this would need to. But let's read the side margin on 80, Mr. President. Yes? Let's read the protection of witnesses. The applicable law without respect to compelling a person to appear before a judge under Section 78 or 79 and to give evidence or ask a question to produce document is the law specified in such. Then it goes on to say, all those notwithstanding. What is the purpose? The protection of witnesses. So my answer is a simple one. Until 77, 78, 79 kick in, 80 is an academic proposition.
That's your response to that?
That's my response.
Oh, I thought you were going to say more. All right. We've got 15 minutes to finish our time with you.
Mr. President, forgive me, Honorable Attorney General, I just don't want to be speaking on Monday about an issue that the Attorney General has not had a chance to address. We have been speaking about the possibility of a sitting in situ. If we did that, then if the trial chamber did that, the International Crimes Act has provisions that deal with that, sections 161 to 167, and we'll have a certain position on that on Monday, obviously, but I just didn't want the Attorney General to return to Nairobi without having an opportunity at least to think about those provisions before he leaves. Thank you.
Mr. Mugai, are you looking at those sections, 161 to 167?
61 of the...
161 to 167 of the ICA.
Yes.
In particular, if you looked at 162 and
Yes.
163,
Yes, I have no difficulty with that. I thought, Mr. President, that I had already affirmed that we as the Republic of Kenya are already on record as saying in both cases that subject to logistics and all the other issues, we have no reason to believe that the ICC cannot sit in this way. But may I draw
163 in particular? If you can look at 163, while the ICC is sitting in Kenya, it may exercise its functions and powers as provided under the Rome Statute and under the ICC rules.
Yeah, that poses no difficulty because the ICC will be sitting as if it were at The Hague.
And the provision, if you can see, it cross-references Rome Statute underneath there, Articles 42 and 64.
164, sir?
64.
64.
I do not know what version. One difficulty we have is the version of the ICA that I have does not have the marginal notes you are reading all along, and I do not know whether the one you are looking at would have the annotation you see underneath the...
Mr. President, with your leave, we'd be delighted to hand up an unmarked copy that has the margin notes for the bench, and perhaps it could be copied later on.
It will assist us, but in the meantime, I do not know whether the version Mr. Attorney has the annotation that appears under the provision. Not that the annotation or the marginal notes would control the interpretation, but it's something of interest to see in any event. So, question is, the provision here, 163, part of the law of Kenya, clearly, so it's no longer theoretical argument. It says that while the ICC sits in Kenya, it can exercise its powers and functions as provided under the Rome Statute. And that would include what we make of the word require. This appears under Article 64, 6b. Does it not?
I want to put it on record again that we have no difficulty whatsoever with this as a general proposition. Say to place this on record again. If the ICC was sitting in Kenya, it would be bound by Article 93E. That is to say, it would have to request me to facilitate the voluntary appearance of persons as witnesses. So we will continue with this chicken and egg, chicken and egg, chicken and egg. Will the ICC be sitting in Kenya if we have no witnesses who have volunteered to testify? And we go back to where we started in the morning. Is the Attorney General under an obligation to arrest, incarcerate, and then bring to the custody of the ICC sitting in Kenya, let us say in the UN headquarters? I have no such power. I wish I would promise I have such power. I don't.
Mr. Attorney, let's, you talk about chicken and egg. Let's address that for a minute. In the morning, when I welcomed you, we noted your impeccable credentials as a lawyer, including immediately former position of the UN Human Rights Council Special Rapporteur on contemporary forms of racism, racial discrimination, xenophobia, and related intolerances.
Indeed.
Right. Racism, xenophobia, related intolerances. Now, when we look at those, what is the most extreme manifestation of those social ills? Genocide, would it not be?
It probably would be, yes.
And what we're looking at here is a situation where we have a case of genocide. And you, the former UN Special Rapporteur, in capacity that encompasses that. And there's a question of whether we have to get to the bottom of it.
Indeed.
In the search for the truth.
Absolutely.
And you were saying that the witness may not be compelled to come, even though the court is sitting in Kenya, and we are looking at the provisions of 162 of the ICA, and you say chicken and egg. Is that where we're left with the question of justice,
Could you,
chicken and egg.
could you permit me once more to break with tradition and put a question to you again? My heart goes out to the people who are the victims of this violence. I do not think there can be any person in the world or any group of people in the world who would be more conscious of the damage that was caused to our people and our country. Having said that, because we are a court of law, and because this is a judicial process, we must conduct it in accordance with the law. Otherwise, the temptation then to say, this has dragged on for too long, let us go into the streets and pick the people we believe we know who did this and line them up and shoot them would be a more attractive proposition. We are jurists. I do not say it flippantly or lightly that we are in a legal conundrum. I wish I had the power to unlock it. But I am an officer who has taken an oath, like you have, dear judges, to protect the law. I would break my oath if I suggested that if I were brought a warrant of arrest from here, I would go into the streets with some policemen and we pick up Mr. Walter Barasa and put him in a plane and send him to The Hague. I would not do that. I would resign my office first. Because the law does not allow me to do the things that my heart tells me. The law tells me to do what the law empowers me to do, irrespective of what my heart may feel. I would want the court, and I have said that, and I don't know whether I should repeat myself. Can the ICC sit in Nairobi? Yes. In fact, it is us who first supported that proposition, and it was rejected by you. So, to turn around and say that that can be visited on us would be very unfair. So, the ICC can sit in Kenya, the ICC can hear witnesses in Kenya, it can take evidence in Kenya, subject to the law. Subject to the law. And therefore, when I therefore want to put it on record for the sake of my learned friend, the prosecutor, that I am aware of the provisions he has referred to, and they pose no difficulty to me. What I think we ought to go back to is, in order for the ICC to come to Nairobi and sit, what would be the evidence it will be considering in its docket in that period? If it is the 7 witnesses that are alleged to have disappeared, whose names I don't know, whose identity I don't know, whose location I do not know, then we would have to have a legal procedure consistent with the treaty, consistent with the statute, and consistent with Kenya law that allows me, because that's the word. I want Mr. Henderson to hear this personally, and therefore I will repeat it. The prosecution has asked you to require us to facilitate the presence of.
You mean Mr. Stewart?
Sorry, I'm sorry about that. That's he knows the other name I have used, and I apologize to him. He's a man I hold in the highest possible regard. But as I was saying, Mr. President, the prosecutor's request is that you should get us to compel the attendance of. And what I have said over and over again is the mechanism for identifying these people, locating them, and then compelling them to be present is a mechanism that is problematic. I don't think that that argument has been made without some reflection on our part. It is not made flippantly. It is not made in a frivolous manner. It is made because this whole 6 hours of argument demonstrate that it is a difficult issue.
Mr. Attorney, you have 2 minutes to finish.
So let me then wrap up by saying...
And Mr. President, sorry to interrupt my learned friend, but I also don't want to raise an issue of Kenyan law in his absence, but I would ask if the learned Attorney General could look at Section 84.
That was going to be my last point.
I'm grateful.
2 minutes, because it's not in my discretion or the discretion of my
I will
colleagues
wrap
to
up
allow
by
you more
saying,
time.
I will wrap up by saying, the comfort that may appear at first sight to be given by Section 80 of the ICA is indeed not a comfort, because 80 subsection 4 creates a very clear exception. And it says, notwithstanding subsection 1, a person who is required under section 78 or 79 to give evidence or produce articles is not required to give evidence or produce any document or any article that the person could not be compelled to give or produce in proceedings before the ICC. We come back to what do you have compellability powers here at The Hague? If you don't have them, even if there was this process in Kenya, you wouldn't have them. Let me now say this. We thank you. We thank you for the opportunity. We thank you for the very engaging discussion, and I thank all my colleagues for their interventions. I want to repeat that the Kenya government remains ready, able, and willing, and desirous to assist this process, but we will do it in accordance with the law. Thank you.
Thank you. We'll leave it at that for now. On Monday, we should take up any replies and responses. We will be doing that in 1 hour, because this witness prosecution, I take it. Mr. Steinberg, you have a witness on Monday, right?
We do indeed have a witness lined up for Monday, yes, Your Honor.
So we can take the first hour and wrap up what needs to be done on this discussion and compellability.
We will convey that to the witness.
Thank you. And thank you very much, everyone. We and Mr. Attorney and your colleagues wish you safe travels back. The court will adjourn.
All rise. We will.